All rise. Division 2 of the Court of Appeals of the State of Washington is now in session. Commissioner Carl Treble presiding. The first case for our July 30th, 2025 docket is a motion for discretionary review, case number 60917-7, Ronald Hughes versus Jerusha Hughes.
Good morning, everyone. Please have a seat. And counsel for petitioner, looks like you've reserved a minute for rebuttal, and you can proceed with your argument when you're ready.
Your Honor. May it please the court, Stephen Swenson for the appellant Jerusha Hughes. The preliminary question for the court today is whether there is a substantial change in the status quo and probable error when a trial court orders a parent who's the primary and strongest bond to the child, but who can't legally enter the country, to send that child to reside with the secondary parent indefinitely, but for her inability to enter the country, she would be able to retain custody. So the first really legal question here is, when is the status quo established?
You say your client's inability to re-enter the country, so your client is trying to re-enter the country and is unable to?
That's correct, Your Honor.
What evidence is that of?
So we submitted a declaration from our client stating that her green card has expired. She submitted her green card, which showed it expired on January 9th. She also stated in a declaration that she's working with an immigration attorney to get a waiver because her green card expired. After they separated, she needed the respondent to co-sign a petition stating that they were still married and planning to reside together. So she can't enter the country. She has no legal status here. It's on her. That answer the question?
Yes, thank you.
Okay. But the court, Judge Cornell ordered in her order, if she is able to enter the country, she could have 50-50 custody. So one of the primary questions here is, under what circumstances could a court order a primary strongest bond to surrender their child to a country they cannot legally enter? And we'll show the court today that those circumstances don't apply here. So, status quo, the respondent would like the court to take a narrow view of status quo of the period of time directly before the filing of relief. And we'd think that the more holistic view, a more harmonious view with the legislative intent that custody orders should look at the best interest of the child, that the status quo should look at when the relief is requested. Before that, the traditional roles of the parents and the child. But
isn't this all just hypothetical, though, until the mother returns with the child?
Well, she's currently ordered to return with the child, and she can't return with the child. So it's if and when she returns with the child, then the court can have a hearing and determine the best interest of the child at that time. The court has already made a preliminary, the court ordered a temporary parenting plan, saying the child's
temporary.
Here. Yes. So the court ordered a temporary parenting plan, placing custody with the secondary parent. So it's not hypothetical. The court's already ordered custody to the father. The timeline's already passed. He's supposed to go retrieve the child, and she's lost custody. So the factors the court needs to look at in determining the placement of custody is in 26.09.187. And the factor with the highest weight is the strength, nature, and stability of each parent with that child. And our client, Jerusha Hughes, has been a stay-at-home mom with a child who's 17 months old now. For the 8 months prior to going to India, she was a stay-at-home mom and the primary caretaker. When she's now in India, 9 months, she's been the sole parent living with her parents.
But she voluntarily absconded to India.
I would refute the term absconded. Yes, she left for India with the child. Her plan was to return. She's unable to return because of her green card. But that's also not a factor in the 187 factors. It doesn't say whether the parent left the state with the child, whether the child resides outside the United States. Now, the court could make 191 factors, which could overrule the 187 factors under the statute, which the legislature allows. But Judge Cornell didn't make any 191 factors. She didn't say she withheld the child and thus she needs to return it. It's reserved on all those factors. So if she had made those findings, it'd be different, but we don't have those circumstances here. And so with no 191 factors, the court has to look at the 187 factors, which the primary factor is the strength of the parent-child bond, which our child is the rock. She's been the one stable factor for this child his entire life. All the other factors as well go to Jerusha Hughes having custody. As the primary caretaker, the emotional needs of the child is 17 months old. He does not have the emotional maturity or the verbal understanding of being removed from his mother. The only factor which slightly weighs in Ronald Hughes' favor is that a sibling lives with him, but that one factor can't outweigh the parental bond. And also, he's been residing with his maternal grandparents now for the last 9 months, so he has bonds with them too. So basically, there's no findings of fact. There's just a legal conclusion that this plan is in the best interest of the child. There's no findings of fact that support Jerusha Hughes losing custody.
Is there any case that you can point to where a parent was found to be the custodial parent despite the fact that they had removed the child from the jurisdiction internationally?
Can you repeat the question?
Is there any case like this where a parent has removed a child to a different country, and yet despite that, the court entered findings saying that it's in the best interest of the child that that parent be the sole custodian of that child?
No, but there's also no case law saying that, or at least no cases I could find that said the opposite of that.
And if there's no case law, then how can it be obvious or probable error?
Because we have the factors that the court must consider in making a custodial determination.
I guess my point is, isn't it a pretty big factor that a parent removed, I mean, I don't know that it's actually technically kidnapping, but arguably kidnapping, removing a child from one parent and taking it to a foreign country, that seems like a pretty big, important factor to consider in determining the best interests of the child.
Yes, and if the court had made that finding, it could order this. She didn't make that finding. Judge Cornell didn't make that finding. She reserved on all 191 factors. She could have made a 191 factor that the mother absconded with the child and withheld the child, but she didn't do that.
Do you contest that basic fact that the mother removed the child to India?
I don't contest that she is in India with the child. They left for India. She needed to get away from her husband. Our position is that this was an abusive, toxic relationship, and she left the country with the child, but she did intend to return. She was unaware that her green card was going to expire because on the green card it says 01/09/2025. The rest of the world would see that as September 1st, 2025.
Isn't there information in the record where they had an argument and she told the father, I'm going to leave and move to India with the child, and she did that the next day?
The father alleges that she constantly threatened to leave the country and with the child. My client disputes that. She never stated that she was going to do that.
Isn't there a way to dispute that by appearing in court and having a hearing?
Yes, she could do, which she did file a pleading, but she can't appear physically in court. She can't enter the country.
And I guess those are circumstances she brought upon herself.
I don't agree. She planned to return to the United States. Her green card expired. And the court made an error by making no findings and making no 191 factors to overrule the 187 factors.
Thank you, counsel.
Thank you.
Good morning, Your Honor, and may it please the court. Nicholas Bartels for the respondent, Mr. Ronald Hughes. This court should deny review in this case because the trial court did in fact have jurisdiction to enter the orders that it did, and the parenting plan was well within its discretion under the circumstances. Additionally, the petitioner's request for a stay should be denied. I'd like to start first with discussing, this kind of giant question of the mom's immigration status. I think on the evidence, it's really an open question. She has stated in her briefing that she is unable to return, but she's also stated that she's actively seeking a waiver, yet there's no evidence of what she's done to actually acquire that waiver. There's no evidence that she ever purchased a return ticket, that, this trip was actually supposed to be temporary in nature. And I think that, the trial court did in fact recognize this, that all of a sudden there was this argument in late October, and then November 1, she absconds to India with the child. I think the evidence that has been presented kind of paints a different picture. I think there was a declaration that was filed with a statement by the petitioner that stated, I'm planning to go to India. I plan to leave the child with my husband. Me not being in the country is not evidence that I've abandoned my child. Admittedly, the plan did change given this argument that the parents got into in late October, but there's no evidence that this was kind of a foregone conclusion.
So if the mother returns with the child, will the court conduct a new parenting plan hearing?
Absolutely. I think, given the situation in this case, the only thing that the trial court could have done was enter a temporary parenting plan, and the temporary parenting plan is only a stopgap measure so that the trial court can do additional fact finding.
So it's fair to say that your client would stipulate that there would be a need for a new hearing if the child were returned and the mother was here.
Absolutely.
Offering to participate in the parenting.
Correct. Yes, I think, and that's the whole point of trial. Discovery has just gone out or is about to go out. And I think, given the circumstances, the trial court did consider the factors under 197, which is the statute that controls a temporary parenting plan. And given the absence of any conclusive evidence, I said, hey, look, we're going to maintain the status quo here. We're going to do 50-50 custody, and then we're going to take these additional measures for additional fact findings. So the trial court did appoint the guardian ad litem to do an investigation. The guardian ad litem has started their investigation. And this is the trial court also ordered that the father submit to drug and alcohol testing.
And my understanding is because there was originally a reconciliation that there was no temporary parenting plan in place before the mother left to India with the child. Is that right?
That's correct, yes. The, kind of addressing this issue of what the status quo was, there isn't really any case law that states exactly what the status quo is. I think if we look at both NG and MR, in those cases, the status quo is whatever existed prior to the order that is being challenged. In this case, essentially the order that's being challenged is the order to return the child to the United States. And that order was effectively entered on November 1st in the DBPO action. That there was a later order that just says the same thing does not alter the status quo. And I think it's fundamentally unfair that the petitioner can just point to the fact that she's been in India for almost 9 months now to say, this is the new status quo.
Is the DVPO order in our record?
It is, yes.
For this MDR?
Yes. It's been attached in the respondent's appendix, kind of the second portion of the appendix. One last thing I'd like to say about the parenting plan is that findings are not specifically required under CR 52 because it is temporary. This is just there to kind of provide for the immediate needs of the child, and then it can always change later. Only after there's been a permanent parenting plan entered is there an increased procedural burden to modify the parenting plan. I'd also like to just quickly address this jurisdictional issue. Petitioner disputes that there's any personal jurisdiction in this case. I think, the facts of this case demonstrate that the trial court does in fact have personal jurisdiction over the petitioner because she did in fact seek affirmative relief in the form of custody determination, child support, and then attorney's fees for a future attorney to continue to litigate in the United States. And also I'd like to just discuss the petitioner's argument that Ralph's is the controlling case in this matter. It's actually not Ralph's, it's the UCCJEA, and notice was proper under the UCCJEA such that the trial court does have determination, or does have jurisdiction in this matter. Lastly, I'd just like to, address the petitioner's request for a stay. A stay in this case would be really inappropriate. Stays are designed to prevent harm, and a stay here would only create additional harm. Granting a stay would effectively hand jurisdiction to India, and it's not clear that India has actually, attempted to assert jurisdiction. The petitioner filed her petition that she allegedly filed in India, but we haven't had any additional updates on the status of that case. Also, that's just going to mean, while this case is pending, assuming the court were to grant review, which it should not, that would just mean, an additional 12 to 15 months that the child remains in India. And, in the likely event that there's an affirmance of the trial court's order, we're just going to have to do this all over again, and that's just only going to create additional harm for the child. Unless the court has any questions, I'd like to see more.
All right, thank you, counsel.
Thank you.
Thank you, counsel. You can proceed when you're ready.
Thank you. I just want to touch quickly on whether there be a parenting plan hearing upon the return to the United States. Most likely not, because the parenting plan, temporary parenting plan in place already says if she's in the country, they get 50-50. So there'd be no change in circumstances or.
Well, it'd be up to your client to ask for one. It sounds like the father's willing to have one if necessary. So my point being, if the child returns, then.
Yeah, we could file a motion for a new temporary parenting plan, but that's that. And also.
Doesn't that go to whether or not there's an effects prong at issue here under 2.3b2?
Well, the issue is yes, if she can return to the country, she can fully litigate it and ask for a new hearing. Problem is she can't return to the country. It's like saying if you win the lottery, then you can ask for this thing. It's like, okay, but it's such a impossibility, well, not improbability. There is a non-zero chance that she gets her waiver, but it's at the discretion of the Secretary of the USCIS, and there's no appeal rights.
All right, thank you, counsel.
Thank you.
The matter will be taken under advisement, and this court will issue a ruling as soon as possible. Thank you.